This is video 3 in a Miami Condo Investing Club series on House Bill 913 Condominium and Cooperative Associations from the 2025 Florida Legislative Session. Topic: Pages 26 through 38 of the comprehensive 92-page House Bill 913 PDF document released by the Florida Legislature. Introduction. Florida is set to implement changes to the state's overarching condo law beginning July 1, 2025. This new legislation, dubbed House Bill 913 or HB 913, aims to assist cash-strapped condo owners to adapt to the changes being implemented as a result of the tragic Surfside condo collapse in June 2021, when nearly 100 people died and a $1 billion settlement was paid out to the families of the victims. The legislation was passed on April 30, 2025, and signed into law by Florida Governor Ron DeSantis on June 23, 2025. In our effort to stay abreast of the latest trends, opportunities, and challenges in the South Florida condo market, we at the Miami Condo Investing Club have obtained a copy of the new legislation, which is available from the Florida Legislature's website as a comprehensive 92-page PDF document. We plan to make a series of videos highlighting the new legislation for educational purposes. All of our videos will feature AI-generated audio based on the voice of Peter Zaleski, the founder of the Miami Condo Investing Club, reading aloud the legislation verbatim. We hope that our videos will provide viewers and listeners alike a convenient way to listen on demand to the revisions while doing other things, including cooking, exercising, or even gardening. Please note, each video will be less than 60 minutes long in order to facilitate distribution on our website of Miami Condo Club, as well as on popular social media networks. It is also worth noting we will do our best to start and stop the videos based on related topics. However, it is possible that the videos at times may jump around from one topic to another. If this happens, please remember our videos are exact readouts of the text of the House Bill 913 PDF document. This video, the third in our series, features pages 26 through 38 of the comprehensive 92-page House Bill 913 PDF document. The text was copied directly from the PDF document and pasted into this video file. No editing was made to the text to create this video. To view the text directly, please visit flsenate.gov/session/bill/2025/913 or alternatively laws.flrules.org/2025/175. If you are seeking independent information, critical analysis, or proprietary research about the South Florida condo market, we would encourage you to consider joining the Miami Condo Investing Club. The club's mission is to foster a community that shares real-time, actionable intelligence on the latest real estate trends, emerging opportunities, and trusted service providers throughout South Florida. Whether you are a do-it-yourself DIY condo buyer or a seasoned real estate professional, the club provides invaluable resources, including up-to-date statistics, expert analysis, and access to tailored consulting services. More information on the club is available at Miami Condo Club. We hope you enjoy video 3 in our series on Florida House Bill 913. This is a readout of pages 26 through 38 of the 92-page House Bill 913 PDF document released by the Florida Legislature. Begin. 13. Financial reporting. Within 90 days after the end of the fiscal year, or annually on a date provided in the bylaws, the association shall prepare and complete or contract for the preparation and completion of a financial report for the preceding fiscal year. Within 21 days after the final financial report is completed by the association or received from the third party, but not later than 180 days after the end of the fiscal year or other date as provided in the bylaws, the association shall deliver to each unit owner by United States mail or personal delivery at the mailing address, property address, email address, or facsimile number provided to fulfill the association's notice requirements, a copy of the most recent financial report, or a notice that a copy of the most recent financial report will be, as requested by the owner, mailed or hand-delivered, or electronically delivered via the internet to the unit owner without charge within 5 business days after receipt of a written request from the unit owner. Evidence of compliance with this delivery requirement must be made by an affidavit executed by an officer or director of the association. The division shall adopt rules setting forth uniform accounting principles and standards to be used by all associations and addressing the financial reporting requirements for multi-condominium associations. The rules must include, but not be limited to, standards for presenting a summary of association reserves, including a good faith estimate disclosing the annual amount of reserve funds that would be necessary for the association to fully fund reserves for each reserve item based on the straight line accounting method. This disclosure is not applicable to reserves funded via the pooling method. In adopting such rules, the division shall consider the number of members and annual revenues of an association. Financial reports shall be prepared as follows. An association that meets the criteria of this paragraph shall prepare a complete set of financial statements in accordance with generally accepted accounting principles. The financial statements must be based upon the association's total annual revenues as follows. 1. An association with total annual revenues of $150,000 or more, but less than $300,000 shall prepare compiled financial statements. 2. An association with total annual revenues of at least $300,000, but less than $500,000 shall prepare reviewed financial statements. 3. An association with total annual revenues of $500,000 or more shall prepare audited financial statements. B1. An association with total annual revenues of less than $150,000 shall prepare a report of cash receipts and expenditures. 2. A report of cash receipts and disbursements must disclose the amount of receipts by accounts and receipt classifications and the amount of expenses by accounts and expense classifications, including, but not limited to, the following as applicable: costs for security, professional and management fees and expenses, taxes, costs for recreation facilities, expenses for refuse collection and utility services, expenses for lawn care, costs for building maintenance and repair, insurance costs, administration and salary expenses, and reserves accumulated and expended for capital expenditures, deferred maintenance, and any other category for which the association maintains reserves. C. An association may prepare, without a meeting of or approval by the unit owners, 1. Compiled, reviewed, or audited financial statements if the association is required to prepare a report of cash receipts and expenditures. 2. Reviewed or audited financial statements if the association is required to prepare compiled financial statements. Or 3. Audited financial statements if the association is required to prepare reviewed financial statements. D. If approved by a majority vote of all the voting interests of the association, an association may prepare 1. A report of cash receipts and expenditures in lieu of a compiled, reviewed, or audited financial statement. 2. A report of cash receipts and expenditures or a compiled financial statement in lieu of a reviewed or audited financial statement. Or 3. A report of cash receipts and expenditures, a compiled financial statement, or a reviewed financial statement in lieu of an audited financial statement. Such meeting and approval must occur before the end of the fiscal year and is effective only for the fiscal year in which the vote is taken. An association may not prepare a financial report pursuant to this paragraph for consecutive fiscal years if the developer has not turned over control of the association. All unit owners, including the developer, may vote on issues related to the preparation of the association's financial reports from the date of incorporation of the association through the end of the second fiscal year after the fiscal year in which the certificate of a surveyor and mapper is recorded pursuant to S. 718.1044E, or an instrument that transfers title to a unit in the condominium which is not accompanied by a recorded assignment of developer rights in favor of the grantee of such unit is recorded, whichever occurs first. Thereafter, all unit owners except the developer may vote on such issues until control is turned over to the association by the developer. Any audit or review prepared under this section shall be paid for by the developer if done before turnover of control of the association. A unit owner may provide written notice to the division of the association's failure to mail or hand deliver him, or her a copy of the most recent financial report within 5 business days after he or she submitted a written request to the association for a copy of such report. If the division determines that the association failed to mail or hand deliver a copy of the most recent financial report to the unit owner, the division shall provide written notice to the association that the association must mail or hand deliver a copy of the most recent financial report to the unit owner and the division within 5 business days after it receives such notice from the division. An association that fails to comply with the division's request may not waive the financial reporting requirement provided in paragraph D for the fiscal year in which the unit owner's request was made and the following fiscal year. A financial report received by the division pursuant to this paragraph shall be maintained, and the division shall provide a copy of such report to an association member upon his or her request. 16. Investment of association funds. A board shall, in fulfilling its duty to manage operating and reserve funds of its association, use best efforts to make prudent investment decisions that carefully consider risk and return in an effort to maximize returns on invested funds. B. An association, including a multi-condominium association, may invest reserve funds in one or any combination of certificates of deposit or in depository accounts at a community bank, savings bank, commercial bank, savings and loan association, or credit union without a vote of the unit owners. Section 8. Paragraphs B through G of subsection 2 of section 718.112 Florida statutes are amended to read 718.112 Bylaws. 2 required provisions. The bylaws shall provide for the following, and if they do not do so, shall be deemed to include the following. B. Quorum, voting requirements, proxies. 1. Unless a lower number is provided in the bylaws, the percentage of voting interests required to constitute a quorum at a meeting of the members is a majority of the voting interests. Unless otherwise provided in this chapter or in the declaration, articles of incorporation, or bylaws, and except as provided in subparagraph D4, decisions shall be made by a majority of the voting interests represented at a meeting at which a quorum is present. 2. Except as specifically otherwise provided herein, unit owners in a residential condominium may not vote by general proxy, but may vote by limited proxies substantially conforming to a limited proxy form adopted by the division. A voting interest or consent right allocated to a unit owned by the association may not be exercised or considered for any purpose, whether for a quorum, an election, or otherwise. Limited proxies and general proxies may be used to establish a quorum. Limited proxies shall be used for votes taken to waive or reduce reserves in accordance with subparagraph F2. For votes taken to waive the financial reporting requirements of S. 718.11113. For votes taken to amend the declaration pursuant to S. 718.110. For votes taken to amend the articles of incorporation or bylaws pursuant to this section, and for any other matter for which this chapter requires or permits a vote of the unit owners. Except as provided in paragraph D, a proxy, limited or general, may not be used in the election of board members in a residential condominium. General proxies may be used for other matters for which limited proxies are not required, and may be used in voting for non-substantive changes to items for which a limited proxy is required and given. Notwithstanding this subparagraph, unit owners may vote in person at unit owner meetings. This subparagraph does not limit the use of general proxies or require the use of limited proxies for any agenda item or election at any meeting of a timeshare condominium association or a non-residential condominium association. 3. A proxy given is effective only for the specific meeting for which originally given and any lawfully adjourned meetings thereof. A proxy is not valid longer than 90 days after the date of the first meeting for which it was given. Each proxy is revocable at any time at the pleasure of the unit owner executing it. 4. A member of the Board of Administration or a committee may submit in writing his or her agreement or disagreement with any action taken at a meeting that the member did not attend. This agreement or disagreement may not be used as a vote for or against the action taken or to create a quorum. 5. A board meeting may be conducted in person or by video conference. A board or committee member's participation in a meeting via telephone, real-time video conferencing, or similar real-time electronic or video communication counts toward a quorum, and such member may vote as if physically present. A speaker must be used so that the conversation of such members may be heard by the board or committee members attending in person, as well as by any unit owners present at a meeting. The division shall adopt rules pursuant to SS 120.536 and 120.54 governing the requirements for meetings. See Board of Administration meetings. In a residential condominium association of more than 10 units, the Board of Administration shall meet at least once each quarter. At least 4 times each year, the meeting agenda must include an opportunity for members to ask questions of the board. Meetings of the Board of Administration at which a quorum of the members is present are open to all unit owners. Members of the Board of Administration may use email as a means of communication, but may not cast a vote on an association matter via email. A unit owner may tape record or videotape the meetings. The right to attend such meetings includes the right to speak at such meetings with reference to all designated agenda items and the right to ask questions relating to reports on the status of construction or repair projects, the status of revenues and expenditures during the current fiscal year, and other issues affecting the condominium. The division shall adopt reasonable rules governing the tape recording and videotaping of the meeting. The association may adopt written reasonable rules governing the frequency, duration, and manner of unit owner statements. 1. Adequate notice of all board meetings, which must specifically identify all agenda items, must be posted conspicuously on the condominium property at least 48 continuous hours before the meeting, except in an emergency. If the board meeting is to be conducted via video conference, the notice must state that such meeting will be via video conference and must include a hyperlink and a conference telephone number for unit owners to attend the meeting via video conference, as well as the address of the physical location where the unit owners can attend the meeting in person. If the meeting is conducted via video conference, it must be recorded, and such recording must be maintained as an official record of the association. If 20% of the voting interest petition the board to address an item of business, the board, within 60 days after receipt of the petition, shall place the item on the agenda at its next regular board meeting or at a special meeting called for that purpose. An item not included on the notice may be taken up on an emergency basis by a vote of at least a majority plus one of the board members. Such emergency action must be noticed and ratified at the next regular board meeting. Written notice of a meeting at which a non-emergency special assessment or an amendment to rules regarding unit use will be considered must be mailed, delivered, or electronically transmitted to the unit owners and posted conspicuously on the condominium property at least 14 days before the meeting. Evidence of compliance with this 14-day notice requirement must be made by an affidavit executed by the person providing the notice and filed with the official records of the association. 2. Upon notice to the unit owners, the board shall, by duly adopted rule, designate a specific location on the condominium property at which all notices of board meetings must be posted. If there is no condominium property at which notices can be posted, notices shall be mailed, delivered, or electronically transmitted to each unit owner at least 14 days before the meeting. In lieu of or in addition to the physical posting of the notice on the condominium property, the association may, by reasonable rule, adopt a procedure for conspicuously posting and repeatedly broadcasting the notice and the agenda on a closed-circuit cable television system serving the condominium association. However, if broadcast notice is used in lieu of a notice physically posted on condominium property, the notice and agenda must be broadcast at least 4 times every broadcast hour of each day that a posted notice is otherwise required under this section. If broadcast notice is provided, the notice and agenda must be broadcast in a manner and for a sufficient continuous length of time so as to allow an average reader to observe the notice and read and comprehend the entire content of the notice and the agenda. In addition to any of the authorized means of providing notice of a meeting of the board, The association may, by rule, adopt a procedure for conspicuously posting the meeting notice and the agenda on a website serving the condominium association for at least the minimum period of time for which a notice of a meeting is also required to be physically posted on the condominium property. Any rule adopted shall, in addition to other matters, include a requirement that the association send an electronic notice in the same manner as a notice for a meeting of the members, which must include a hyperlink to the website at which the notice is posted, to unit owners whose email addresses are included in the association's official records. 3. Notice of any meeting in which regular or special assessments against unit owners are to be considered must specifically state that assessments will be considered and provide the estimated cost and description of the purposes for such assessments. If an agenda item relates to the approval of a contract for goods or services, a copy of the contract must be provided with a notice and be made available for inspection, and copying upon a written request from a unit owner or made available on the association's website or through an application that can be downloaded on a mobile device. 4. Meetings of a committee to take final action on behalf of the board or make recommendations to the board regarding the association budget are subject to this paragraph. Meetings of a committee that does not take final action on behalf of the board or make recommendations to the board regarding the association budget are subject to this section, unless those meetings are exempted from this section by the bylaws of the association. 5. Notwithstanding any other law, the requirement that board meetings and committee meetings be open to the unit owners does not apply to a. Meetings between the board or a committee and the association's attorney with respect to proposed or pending litigation, if the meeting is held for the purpose of seeking or rendering legal advice, or b. Board meetings held for the purpose of discussing personnel matters. D. Unit owner meetings. 1. An annual meeting of the unit owners must be held at the location provided in the association bylaws, and if the bylaws are silent as to the location, the meeting must be held within 15 miles of the condominium property or within the same county as the condominium property. However, such distance requirement does not apply to an association governing a timeshare condominium. If a unit owner meeting is conducted via video conference, a unit owner may vote electronically in the manner provided in S. 718.128. 2. Unit owner meetings, including the annual meeting of the unit owners, may be conducted in person or via video conference. If the annual meeting of the unit owners is conducted via video conference, a quorum of the members of the Board of Administration must be physically present at the physical location where unit owners can attend the meeting. The location must be provided in the association bylaws, and if the bylaws are silent as to the location, the meeting must be held within 15 miles of the condominium property or within the same county as the condominium property. If the unit owner meeting is conducted via video conference, the video conference must be recorded, and such recording must be maintained as an official record of the association. The division shall adopt rules pursuant to SS 120.536 and 120.54 governing the requirements for meetings. 3. Unless the bylaws provide otherwise, a vacancy on the board caused by the expiration of a director's term must be filled by electing a new board member, and the election must be by secret ballot. An election is not required if the number of vacancies equals or exceeds the number of candidates. For purposes of this paragraph, the term candidate means an eligible person who has timely submitted the written notice, as described in subparagraph 4. A. Of his or her intention to become a candidate. Except in a timeshare or non-residential condominium, or if the staggered term of a board member does not expire until a later annual meeting, or if all members' terms would otherwise expire, but there are no candidates, the terms of all board members expire at the annual meeting, and such members may stand for re-election unless prohibited by the bylaws. Board members may serve terms longer than 1 year if permitted by the bylaws or articles of incorporation. A board member may not serve more than 8 consecutive years unless approved by an affirmative vote of unit owners representing 2/3 of all votes cast in the election, or unless there are not enough eligible candidates to fill the vacancies on the board at the time of the vacancy, Only board service that occurs on or after July 1st, 2018 may be used when calculating a board member's term limit. If the number of board members whose terms expire at the annual meeting equals or exceeds the number of candidates, the candidates become members of the board effective upon the adjournment of the annual meeting. Unless the bylaws provide otherwise, any remaining vacancies shall be filled by the affirmative vote of the majority of the directors making up the newly constituted board, even if the directors constitute less than a quorum or there is only one director. In a residential condominium association of more than 10 units, or in a residential condominium association that does not include timeshare units or timeshare interests, co-owners of a unit may not serve as members of the board of directors at the same time, unless they own more than one unit, or unless there are not enough eligible candidates to fill the vacancies on the board at the time of the vacancy. A unit owner in a residential condominium desiring to be a candidate for board membership must comply with subparagraph 4A and must be eligible to be a candidate to serve on the board of directors at the time of the deadline for submitting a notice of intent to run in order to have his or her name listed as a proper candidate on the ballot or to serve on the board. A person who has been suspended or removed by the division under this chapter, or who is delinquent in the payment of any assessment due to the association, is not eligible to be a candidate for board membership and may not be listed on the ballot. For purposes of this paragraph, a person is delinquent if a payment is not made by the due date as specifically identified in the declaration of condominium, bylaws, or articles of incorporation. If a due date is not specifically identified in the declaration of condominium, bylaws, or articles of incorporation, the due date is the first day of the assessment period. A person who has been convicted of any felony in this state or in a United States district or territorial court, or who has been convicted of any offense in another jurisdiction which would be considered a felony if committed in this state, is not eligible for board membership unless such felon's civil rights have been restored for at least 5 years as of the date such person seeks election to the board. The validity of an action by the board is not affected if it is later determined that a board member is ineligible for board membership due to having been convicted of a felony. This subparagraph does not limit the term of a member of the board of a non-residential or timeshare condominium. 4. The bylaws must provide the method of calling meetings of unit owners, including annual meetings. Written notice of an annual meeting must include an agenda, be mailed, hand-delivered, or electronically transmitted to each unit owner at least 14 days before the annual meeting, and be posted in a conspicuous place on the condominium property or association property at least 14 continuous days before the annual meeting. Written notice of a meeting other than an annual meeting must include an agenda, be mailed, hand-delivered, or electronically transmitted to each unit owner, and be posted in a conspicuous place on the condominium property or association property within the time frame specified in the bylaws. If the bylaws do not specify a time frame for written notice of a meeting other than an annual meeting, notice must be provided at least 14 continuous days before the meeting. Upon notice to the unit owners, the board shall, by duly adopted rule, designate a specific location on the condominium property or association property at which all notices of unit owner meetings must be posted. This requirement does not apply if there is no condominium property for posting notices, and in addition to the physical posting of meeting notices, the association may, by reasonable rule, adopt a procedure for conspicuously posting and repeatedly broadcasting the notice and the agenda on a closed-circuit cable television system serving the condominium association. If broadcast notice is provided, the notice and agenda must be broadcast in a manner and for a sufficient continuous length of time so as to allow an average reader to observe the notice and read and comprehend the entire content of the notice and the agenda. In addition to any of the authorized means of providing notice of a meeting of the board, the association may, by rule, adopt a procedure for conspicuously posting the meeting notice and the agenda on a website serving the condominium association for at least the minimum period of time for which a notice of a meeting is also required to be physically posted on the condominium property. Any rule adopted shall, in addition to other matters, include a requirement that the association send an electronic notice in the same manner as a notice for a meeting of the members which must include a hyperlink to the website at which the notice is posted to unit owners whose email addresses are included in the association's official records. Unless a unit owner waives in writing the right to receive notice of the annual meeting, such notice must be hand-delivered, mailed, or electronically transmitted to each unit owner. Notice for meetings and notice for all other purposes must be mailed to each unit owner at the address last furnished to the association by the unit owner or hand-delivered to each unit owner. However, if a unit is owned by more than one person, the association must provide notice to the address that the developer identifies for that purpose, and thereafter, as one or more of the owners of the unit advise the association in writing, or if no address is given or the owners of the unit do not agree to the address provided on the deed of record. An officer of the association or the manager or other person providing notice of the association meeting must provide an affidavit or United States Postal Service certificate of mailing to be included in the official records of the association affirming that the notice was mailed or hand-delivered in accordance with this provision. 5. The members of the board of a residential condominium shall be elected by written ballot or voting machine. Proxies may not be used in electing the board in general elections or elections to fill vacancies caused by recall, resignation, or otherwise, unless otherwise provided in this chapter. This subparagraph does not apply to an association governing a timeshare condominium. A. At least 60 days before a scheduled election, the association shall mail, deliver, or electronically transmit, by separate association mailing, or included in another association mailing, delivery, or transmission, including regularly published newsletters, to each unit owner entitled to a vote, a first notice of the date of the election. A unit owner or other eligible person desiring to be a candidate for the board must give written notice of his or her intent to be a candidate to the association at least 40 days before a scheduled election, together with the written notice and agenda as set forth in subparagraph 3. The association shall mail, deliver, or electronically transmit a second notice of the election to all unit owners entitled to vote, together with a ballot that lists all candidates not less than 14 days or more than 34 days before the date of the election. Upon request of a candidate, an information sheet no larger than 8.5 inches by 11 inches, which must be furnished by the candidate at least 35 days before the election, must be included with the mailing, delivery, or transmission of the ballot, with the costs of mailing, delivery, or electronic transmission and copying to be borne by the association. The association is not liable for the contents of the information sheets prepared by the candidates. In order to reduce costs, the association may print or duplicate the information sheets on both sides of the paper. The division shall by rule establish voting procedures consistent with this subparagraph, including rules establishing procedures for giving notice by electronic transmission and rules providing for the secrecy of ballots. Elections shall be decided by a plurality of ballots cast. There is no quorum requirement. However, at least 20% of the eligible voters must cast a ballot in order to have a valid election. A unit owner may not authorize any other person to vote his or her ballot, and any ballots improperly cast are invalid. A unit owner who violates this provision may be fined by the association in accordance with S. 718.303. A unit owner who needs assistance in casting the ballot for the reasons stated in S. 101.051 may obtain such assistance. The regular election must occur on the date of the annual meeting. Notwithstanding this subparagraph, an election is not required unless more candidates file notices of intent to run or are nominated than board vacancies exist. B. A director of a board of an association of a residential condominium shall: I certify in writing to the Secretary of the Association that he or she has read the Association's Declaration of Condominium, Articles of Incorporation, bylaws, and current written policies, that he or she will work to uphold such documents and policies to the best of his or her ability, and that he or she will faithfully discharge his or her fiduciary responsibility to the Association's members. Roman 2. Submit to the Secretary of the Association a certificate of having satisfactorily completed the educational curriculum administered by the division or a division-approved condominium education provider. The educational curriculum must be at least 4 hours long and include instruction on milestone inspections, structural integrity reserve studies, elections, record keeping, financial literacy and transparency, levying of fines and notice and meeting requirements. Each newly elected or appointed director must submit to the Secretary of the Association the written certification and educational certificate within 1 year before being elected or appointed or 90 days after the date of election or appointment. A director of an association of a residential condominium who was elected or appointed before July 1st, 2024, must comply with the written certification and educational certificate requirements in this subparagraph by June 30th, 2025. The written certification and educational certificate is valid for 7 years after the date of issuance and does not have to be resubmitted as long as the director serves on the board without interruption during the 7-year period. A director who is appointed by the developer may satisfy the educational certificate requirement in subparagraph Roman 2 for any subsequent appointment to a board by a developer within 7 years after the date of issuance of the most recent educational certificate, including any interruption of service on a board or appointment to a board in another association within that 7-year period. 1 year after submission of the most recent written certification and educational certificate, and annually thereafter, a director of an association of a residential condominium must submit to the Secretary of the Association a certificate of having satisfactorily completed at least 1 hour of continuing education administered by the division or a division-approved condominium education provider relating to any recent changes to this chapter and the related administrative rules during the past year. A director of an association of a residential condominium who fails to timely file the written certification and educational certificate is suspended from service on the board until he or she complies with this subparagraph. The board may temporarily fill the vacancy during the period of suspension. The Secretary shall cause the association to retain a director's written certification and educational certificate for inspection by the members for 7 years after a director's election or the duration of the director's uninterrupted tenure, whichever is longer. Failure to have such written certification and educational certificate on file does not affect the validity of any board action. C. Any challenge to the election process must be commenced within 60 days after the election results are announced. 6. Any approval by unit owners called for by this chapter or the applicable declaration or bylaws, including, but not limited to, the approval requirement in S. 718.1118, must be made at a duly noticed meeting of unit owners and is subject to all requirements of this chapter or the applicable condominium documents relating to unit owner decision-making, except that unit owners may take action by written agreement without meetings on matters for which action by written agreement without meetings is expressly allowed by the applicable bylaws or declaration or any law that provides for such action. 7. Unit owners may waive notice of specific meetings if allowed by the applicable bylaws or declaration or any law. Notice of meetings of the Board of Administration. Unit owner meetings, except unit owner meetings called to recall board members under paragraph L, and committee meetings may be given by electronic transmission to unit owners who consent to receive notice by electronic transmission. A unit owner who consents to receiving notices by electronic transmission is solely responsible for removing or bypassing filters that block receipt of mass emails sent to members on behalf of the association in the course of giving electronic notices. 8. Unit owners have the right to participate in meetings of unit owners with reference to all designated agenda items. However, the association may adopt reasonable rules governing the frequency, duration, and manner of unit owner participation. 9. A unit owner may tape record or videotape a meeting of the unit owners subject to reasonable rules adopted by the division. 10. Unless otherwise provided in the bylaws, any vacancy occurring on the board before the expiration of a term may be filled by the affirmative vote of the majority of the remaining directors, even if the remaining directors constitute less than a quorum, or by the sole remaining director. In the alternative, a board may hold an election to fill the vacancy, in which case the election procedures must conform to subparagraph 4. A. unless the association governs 10 units or fewer and has opted out of the statutory election process, in which case the bylaws of the association control. Unless otherwise provided in the bylaws, a board member appointed or elected under this section shall fill the vacancy for the unexpired term of the seat being filled. Filling vacancies created by recall is governed by paragraph L and rules adopted by the division. 11. This chapter does not limit the use of general or limited proxies, require the use of general or limited proxies, or require the use of a written ballot or voting machine for any agenda item or election at any meeting of a timeshare condominium association or non-residential condominium association, notwithstanding subparagraph B2 and subparagraph 4. A. An association of 10 or fewer units may, by affirmative vote of a majority of the total voting interests, provide for different voting and election procedures in its bylaws, which may be by a proxy specifically delineating the different voting and election procedures. The different voting and election procedures may provide for elections to be conducted by limited or general proxy. E-budget meeting. 1. Any meeting at which a proposed annual budget of an association will be considered by the board or unit owners shall be open to all unit owners. A meeting of the board or unit owners at which a proposed annual association budget will be considered may be conducted by video conference. The division shall adopt rules pursuant to SS 120.536 and 120.54 governing the requirements for such meetings. A sound transmitting device must be used so that the conversation of such members may be heard by the board or committee members attending in person, as well as any unit owners present at the meeting. At least 14 days before such a meeting, the board shall hand deliver to each unit owner, mail to each unit owner at the address last furnished to the association by the unit owner, or electronically transmit to the location furnished by the unit owner for that purpose a notice of such meeting and a copy of the proposed annual budget. An officer or manager of the association or other person providing notice of such meeting shall execute an affidavit evidencing compliance with such notice requirement, and such affidavit shall be filed among the official records of the association. 2. A. If a board proposes in any fiscal year an annual budget which requires assessments against unit owners which exceed 115% of assessments for the preceding fiscal year, the board shall simultaneously propose a substitute budget that does not include any discretionary expenditures that are not required to be in the budget. The substitute budget must be proposed at the budget meeting before the adoption of the annual budget. At least 14 days before such budget meeting in which a substitute budget will be, the board shall hand deliver to each unit owner or mail to each unit owner at the address last furnished to the association a notice of the meeting. An officer or manager of the association or other person providing notice of such meeting shall execute an affidavit evidencing compliance with this notice requirement, and such affidavit shall be filed among the official records of the association. Unit owners must consider and may adopt a substitute budget at the meeting. A substitute budget is adopted if approved by a majority of all voting interests, unless the bylaws require adoption by a greater percentage of voting interests. If a substitute budget is not adopted, the annual budget previously initially proposed by the board may be adopted. B. Any determination of whether assessments exceed 115% of assessments for the prior fiscal year shall exclude any authorized provision for required reserves for repair or replacement of the condominium property, anticipated expenses of the association which the board does not expect to be incurred on a regular or annual basis for the repair, maintenance, or replacement of the items listed in paragraph G, and insurance premiums. C. If the developer controls the board, assessments may not exceed 115% of assessments for the prior fiscal year unless approved by a majority of all voting interests. This concludes the readout of pages 26 through 38 of the comprehensive 92-page Florida House Bill 913 PDF document. To view the text directly, please visit flsenate.gov/session/bill/2025/913 or alternatively laws.flrules.org/2025/175. Thanks for watching. For full access to our comprehensive reports, statistical charts, virtual monthly meetings, and exclusive meetup events, we invite you to join the Miami Condo Investing Club at Miami Condo Club. The club's mission is to foster a community that shares real-time, actionable intelligence on the latest real estate trends, emerging opportunities, and trusted service providers throughout South Florida. Whether you are a do-it-yourself DIY condo buyer or a seasoned real estate professional, the club provides invaluable resources, including up-to-date statistics, expert analysis, and access to tailored consulting services. An added benefit of the club is that members receive discounts on all Miami Condo Correction walking tours. Please visit miamicondoclub.eventbrite.com for a schedule of upcoming tours. To view additional videos, please visit Miami Condo Club. This concludes our video.